that in the well-known case of Shambhuram Yadav, Honorable Justice K.Y. Sabarwal has quoted an important paragraph about the profession. Just I will quote it. Justice Sabarwal in the reported judgment, which is reported in 2001 Supreme Court 2509, has observed, I will read, legal profession is not a trade or business. It is a noble profession. Members belonging to this profession have not to encourage dishonesty and corruption, but have to strive to secure justice to their clients if it is legally possible. The credibility and reputation of the profession depends upon the manner in which the members of the profession conduct themselves. There is heavy responsibility on those on whom duty has been vested under the Advocates Act 1961 to take disciplinary action when the credibility and reputation of the profession comes under a cloud on account of acts of omission and commission by any member of the profession. Now, therefore, in clear terms, the Honorable Apex Court said that advocate has to practice, he has to try to give justice to his client, but it is in the legal ways and not by way of corrupt practices it is. And therefore, friends, the profession of advocate is governed under the provisions of Advocates Act 1961, which is a central act enacted by Parliament and applicable from 1961. I will refer few provisions before coming to the subject matter, that under Section 3 of the Advocates Act, there is provision to establishment of the State Bar Council to regulate the profession of advocate, that is, they are maintaining their role, to control them and to take disciplinary action, etc. It is a statutory authority, whereas Section 4 provides a Bar Council of India, an apex body in the country, all state bar councils. Section 5 of the Act provides that the Bar Council to be a body corporate with a common seal, which can be sued and can be sued in its name. Whereas Section 6 prescribes functions of the State Bar Council. The Bar Council of India is a rule-making authority. Those powers are not with the State Bar Councils. Therefore, friends, to regulate the internal business, the Bar Council of India has enacted Bar Council of India rules. Under Section 9 of the said Act, the provision is made to constitute a disciplinary committee, whereas the powers of disciplinary committee or to take action are vested with the state bar councils, whereas BCI is an apex body. Friends, under the rule, under Chapter 5, Rule 6, Part 6 of the Bar Council of India rules, it is in regards to the rules governing advocates. Chapter 2, under Part 6 of the Bar Council of India rules, provides standards and professional conduct and etiquettes. So far as today's subject is concerned, we are concerned basically with Chapter 2. Chapter 2 under Part 6 of the Bar Council of India rules, which provides standards and professional conduct and etiquettes. Even under the Act and the rules, it is the profession of the advocate is recognized as a noble profession because the duties of the advocate and the different kind of duties are expected from the advocate. Rules are silent about the powers of the advocate. Everywhere, he is kept under the obligation of his duties. And therefore, friends, under Bar Council of India rules, the different duties are casted on the advocates, and those are divided in different parts, divisions, that is, duty towards the court, duty towards client, duty towards opponent, duty towards colleagues, duty in imparting training, and duty to render legal aid. Therefore, friends, we should consider that different obligations are made which are to be followed by the advocate under the caption of his duties. There are several duties casted on the advocate. So far as duty to the court, basically, it is a first duty of the advocate to conduct himself with dignity and self-respect. However, if he has serious complaint against the judicial officer, it shall his right and duty to submit the grievance to the proper authorities. However, he has also a prime duty to his client, and therefore, while practicing, advocate has to balance the duty towards the court and duty towards the client. While duty to the court, he shall maintain respectful attitude and dignity of the judicial office. He shall not influence the decision of the court by illegal or improper means. He shall appear before the court in a prescribed dress and several other duties casted on the advocate, but some important I mentioned before you. So far as duty to the clients, an advocate is duty bound to accept a brief from any client who approaches him. Generally, advocates should not refuse to accept the brief except there is good and sufficient reason. Whereas the rules framed by the Bar Council of India specifically says that morally advocate cannot refuse to accept the brief on the ground that client is not able to pay the fees as expected by lawyer, because it is held to be a social service and it is totally distinct and different from trade and the business. Second duty casted to the client is that he cannot withdraw from the brief without sufficient cause and without notice to the client, so that he must know that he is unrepresented or his advocate will not represent henceforth. Third important duty towards the client is that advocate shall not accept the brief in case he is a witness and party to the document. Either he should choose that whether he should be an advocate of his client if he is a party to the document, or he should be a witness to the document. He cannot accept both the roles. Last and important duty is that towards the client is that the advocate should not appear in the matter against the client where initially he was represented in the same subject matter, so that he cannot disclose the documents and the privacy of documents of the client. These are some relevant duties casted on the advocate to his client. So far as duty to opponent is concerned, the advocate shall not in any way communicate or negotiate with the party. And if there is occasion to negotiate, except through his advocate, he cannot negotiate directly with the party. That is the duty casted on the advocate to the opponents. Most important part is that duty to the colleagues. Under this caption or section, the advocate shall not solicit work or advertise directly or indirectly by any means. An advocate shall not accept fees less than fees taxable under the rules. It appears that this is the only protection under the rules to the lawyers, that at least it is said that if some fees is prescribed, he shall not accept the brief by accepting less fees than the prescribed fees. An advocate shall not enter appearance or wakalatnama in any matter if some other advocate or counsel is appearing in the matter, and if at all there is occasion to appear in such a matter, then without consent, written consent of the advocate, he shall not accept the brief, or shall not enter his wakalatnama in such a brief. In short, the advocate has to render the duties to our colleagues, maintaining the dignity of profession, and there should not be an internal dispute in between the lawyers. Therefore, friends, initially I told that Bar Council is a statutory body and the authority to control the profession, legal profession. Whereas Section 35 of the Advocates Act provides punishment for misconduct committed by advocates. The State Bar Council has power to deal with the cases of misconduct against the advocates. Now, friends, I tried my level best, but I didn't find a definition of misconduct. It is not defined under the Advocates Act nor the rules. And therefore, initially, I taken your time to point out what are the duties casted on the advocate, and those duties are just like a liabilities of the advocate. He has to follow it morally and practice during his practice. He should follow the norms laid down under the rules. Therefore, coming to Section 35, it provides powers to the Bar Council to punish the advocate if it is proved that he has conducted misconduct. He has committed the misconduct. The powers are given to the Bar Council to decide the matters, either on an application or complaint filed by a party or the advocate. Because it is not that only the party can file complaint of misconduct, even other side also can file the complaint of misconduct. Even other side advocate can file a complaint. The Bar Council is bound to entertain the complaint. Secondly, there are so much of powers with the Bar Council. If Bar Council has reason to believe that some advocate has committed misconduct, then Bar Council can issue a notice, so much of notice, and can take so much of cognizance to deal with the matter. The Bar Council, the Advocate Act provides a committee to deal with the cases of misconduct. Under Section 9, a disciplinary committee has to be formed by the Bar Council after its establishment. It provides that 3 members committee should decide the matters or complaints filed in writing, or if so moto cognizance is taken by the Bar Council. 3 members committee is constituted, has to be constituted in which 2 elected members of the Bar Council are necessary, and 1 senior most advocate at local level or any prominent advocate should be a 3rd member of the committee. It is expected that if 3rd member, which is not elected member, is a senior most, even they are the Bar Councillors, he should be a chairman of that committee. And accordingly, Bar Council has to conduct the cases, that disciplinary committee has to conduct the cases by giving reasonable opportunity to both the sides. And then punishments are provided. Those relates to the gravity of the misconduct proved, if fatality is proved. 3 types of punishments are provided. If no misconduct is found, the complaint can be dismissed. If some misconduct on the part of advocate is established, but which is not so grave, the punishment of reprimand of the advocate can be given. If there is some serious thing, the committee can suspend the son of the advocate for 1 or 2 years. It depends on the gravity of the misconduct committed by the advocate. And final punishment is a removal of the advocate from role, that is debarring him from practice if there is grave misconduct committed by the advocate. These are the powers vested with the Bar Council. So far as punishment of misconduct is concerned, this is not a final authority. If some advocate is punished or some punishment is awarded under Section 35 by the disciplinary committee of Bar Council of Maharashtra and Goa or the State Bar Council, the party aggrieved is entitled to file appeal under Section 37 of the Act to apex body, that is Bar Council of India. However, even Bar Council of India is not a final authority, and final authority or last appeal is provided under Section 38 directly to the Supreme Court. These are the legal remedies available to the advocates in respect of conduct of the matters regarding commission of misconduct by an advocate. Friends, as earlier I have stated, that term misconduct is not defined, and therefore, how to deal with the cases of misconduct. Hence, we have to go towards the duties of the advocates, which I have elaborately discussed, and those are in 6 sections. So far as the duties casted to court, to colleague, to opponent, and to other side, it appears that if there is breach or there is violation of the rules, it can be construed as a misconduct. Therefore, I said that the conduct which is not proper, which is improper, not only that, you have to establish that it is against the profession, against the dignity of profession. It has caused the loss to client or the aggrieved party. Then according to me, it can be a misconduct. As there is no strict definition of misconduct, improper behavior while professing the advocacy can be treated as a misconduct. And therefore, law is developed by different judgments of the apex body, that is Bar Council of India, and basically by the Honorable High Court and the Apex Court of India. As there is no strict definition of misconduct, it has to be established on the facts mentioned in the complaint. And it has to be proved that advocate failed in his duty and his act was intentional within his knowledge. For example, I will just clarify one important thing, that there is distinction so far as negligence and misconduct is concerned. Any negligence by an advocate, negligence on the part of advocate in due course or without any intention cannot be treated as an misconduct. However, even if there is allegation of negligence, duty casted on the advocate to point out that it was not intentional, it was not with intention to cause any injury to his client. If by taking all precautions, some negligence is due to some negligence of the advocate, some client has suffered. For example, I can say that if any case is dismissed in default because of the negligence of the advocate, though he has taken total care and caution to conduct the matter, it can be just negligence and it should not be treated as an misconduct on the part of the advocate. To differentiate all this, or to consider what is a difference in between negligence and misconduct, there is a known case decided by the Honorable Apex Court I will quote here that in the case of PV Kumaravellu versus BCI, reported in 1997, Supreme Court, page number 1014, the Honorable Apex Court has carved out a distinction between negligence and misconduct. There the case was that a BGI advocate has taken all care and caution to conduct a matter of his client. However, he was busy in other court, though he taken care of the matter on board of the complainant, but his matter was dismissed in default. It was treated as a misconduct on the part of advocate because client says that he paid the fees and no proper care was taken by the advocate, and it is a misconduct on his part. Initially, Bar Council has taken view against the advocate. Lastly, matter went to the Apex Court. Considering the facts of the case, and the Honorable Apex Court held that misconduct is totally distinct and different from it just negligence. And therefore, for a case of negligence, the advocate cannot be punished under Section 35, holding that he has committed a misconduct. In such manner, the law is developed, and there are different judgments or different points where the cases of misconducts are considered. Therefore, while dealing with the cases under Section 35, the basic things required to be considered that whether advocate has followed his professional ethics and etiquettes, whether he did his job as required by law, there is no illegal, he has not adopted illegal means, he has not committed a corrupt practice, he acted in the interest of client, and therefore any advocate can establish that he did not commit any misconduct. And therefore, elaborately, initially, I told that in 6 sections or divisions, the duties are casted on the advocate, which has to follow strictly. It is a question to be searched whether it is possible to follow all these norms. But without intention, ill intention, if some mistake is cropped up, it cannot be termed as a misconduct to be dealt under Section 35 of the Advocates Act. However, several acts committed by the advocate are treated as misconduct, and law is developed by the Apex Court of India, even some judgments of the High Court. Matter did not went to the Apex Court, but Honorable High Court has taken some view and law laid down on that point. Friends, duty to the clients under rule, it is provided that the advocate should not be party to the document. If he is a party to the document, then he cannot appear in the matter as a counsel of the party. If knowing fully well that the advocate is party to the document and he appeared in the matter, the Honorable High Court has taken the view that it amounts to a misconduct and therefore advocate is liable for punishment under Section 35. It is a reported judgment in 1993 MLJ, wherein it is held that the advocate who is party to the document is appearing in the matter, it amounts to a misconduct. The law is developed by such a way to consider the cases of misconduct. Friends, one of the facets of the matter requires to be considered is that whether the advocate can purchase a property of client. Actually, the property which is a subject matter of the litigation and litigation is finalized. Generally, it can be said that what is a harm to purchase the such property by an advocate. However, a matter came before the Honorable Court on such a point that where the advocate had purchased the property of his client in the litigation where he was appearing, not in market price, but at some low rates. Thereafter, complaint was made by the client that the advocate has influenced me during the proceedings, and therefore I agree to sell the land to him, to property to him. It was sold, and the advocate has purchased by paying lower rates. Matter went to the apex court, and apex court held that a conduct of the advocate was not proper, and it amounts to a misconduct where he purchased the property in litigation by paying a less price, that is not a market price. That is a well-known judgment of the apex court. I will give a citation. It is reported in 1997, AR 1997, Supreme Court Weekly, page number 4257, which has thrown the light on such subjects or the subject involved in that matter. I will take to you to one of the most important subjects, which also held to a misconduct during the practice of advocate. If an advocate as a counsel created situation resulting into false compromise or made a false compromise apparently detrimental to the interest of his client, generally it is the plea of advocates that compromise was with consent of the party, it was in his interest, etc. But if it is proved that the situation was created to arrive at a compromise which was detrimental to the interest of the party, or there is false compromise, the Honorable Apex Court has held that it amounts to a misconduct and advocate is liable for punishment. I will quote the judgment which is reported in 2001, volume 1, Maharashtra Law Reporter, page number 630. And therefore, while entering into the compromise even on behalf of the client, advocates should be cautious. He should see that subsequently client would not make any allegation. Otherwise, sometimes he should be dragged into the cases of misconduct. It is a part of the profession, and therefore every advocate should be cautious even dealing with the compromise in the matter. Friends, these are the few examples where Apex Court has held that how advocates commit the misconduct. Even during practice, we have to consider that while acting as an advocate, the judicial officer or judge should not be scandalized. In one of the case, the advocate has drafted the notice on behalf of client, scandalizing the judicial officer. And then matter came before the disciplinary committee and then to the court of law. Here, it was the case that the advocate has scandalized the judicial officer. It amounts to a misconduct. It was a stand of advocate that just he has given the notice as said by his client, and therefore it is not his fault. It was the notice based on the instructions of his client. However, the Honorable High Court has held that even while drafting the notice, advocate is duty bound to the court and he has to see that judicial officer, there should not be any aspirations or stigma against the judicial officer. In short, there should not be scandalization of the judicial officer. And it was held that it amounts to a misconduct. And advocate was punished. That is the reported judgment. I will give the citation, that is 2005, volume 1, reported in Maharashtra Law Journal, page number 651. And therefore, friends, while you are issuing the notices or drafting the reply to the notices, we should be cautious to see that whether we owe to the duty of Honorable Court and the judiciary, and even to the client. We have to balance both the things during our practice. Otherwise, we have to face the cases of misconduct. One of the example I am giving Generally, it is alleged by the clients. Sorry. That advocate has taken excess fees as a court fees, or the court is accepted but not deposited, and amount is misappropriated. Nowadays, there are general complaints by the clients on such subjects. However, in one of the matter, complaint was filed by the client saying that though no court fees was required, the advocate has obtained huge amount from him, not deposited in the court, as it was not even required, and he's committed a misappropriation of the court fees paid to him. When such a disputed question came before the Honorable Court, basically it was duty on the complainant first to establish that he paid the fees. But unfortunately, in that matter, the client has established that he paid the amount to the advocate, which was accepted under the garb of court fees. He also established that it was not required, not paid, and therefore it was proved that the advocate has misappropriated the amount under the garb of court fees. The Honorable Apex Court has seriously taken the matter on both the grounds that this is misappropriation of the amount by one hand, and secondly, it is a fraud played to the advocate, to the client, and therefore it amounts to misconduct. The advocate was punished by suspending his sanat for 2 years. Not only this, he was directed to deposit the amount misappropriated, and even cost was imposed on that. Friends, it always happened during the practice, but everybody should be cautious that nobody can raise such allegations which amounts to a misappropriation and even fraud. We are entitled to charge our fees as per our standing and nature of the matter, which itself is provided under the rules. But it is not expected that we should collect some amount by other means like this. And therefore, though there is no definition of misconduct, such subjects are treated as a misconduct under Section 35, and the advocates are punished. That judgment is reported in 2012, volume 7, Supreme Today, page number 33. Therefore, considering the different cases where the law is laid down by the Apex Court, in short, I can say that the improper practice, which is not expected under the Act and rules, the behavior of the advocate, which is improper, immoral, which is beyond the expectation as a social service, in short, can be treated as misconduct, though it is not strictly defined. Lastly, I conclude this session by pointing out one of the interested case, because it is admitted or admitted under the rules also that first duty of the advocate to the Honorable Court. So also, advocate has a prime duty to his client, and advocate is bound to safeguard the interests of his client and try to give justice to him. Now, basically, general public can say that if it is a prime duty of the advocate to see that his client will get justice, then advocate can do anything and to win the matter in the interest of his client. But friends, here we have to balance our duties first to the court and prime duty to the client. Otherwise, we have to face the situation which lead to the misconduct. Here is one of the interested case. Just I will take 2 minutes to give the facts. Here, one of the senior most advocate was knowing that the matter of his client before a particular judge is going on, and that judge is a corrupt judge. Somewhere somebody told to his client, and therefore client wrote a letter to advocate that he heard that unless the judge accept bribe, he will not get the justice. And in reply to his letter, the advocate replied that yes, he also aware of this thing, and therefore he should pay the amount. Actually, it was not his advice. And he replied the letter of the client because he felt that it is in the interest of his client, otherwise he will lose the matter and other side will win, and therefore he replied in that fashion. Friends, there was complaint before the Bar Council that the advocate has committed misconduct because he has promoted or provoked his client to pay the bribe to the judicial officer. Initially, Bar Council has taken a view against the advocate and she was punished. However, some documents was not properly considered, and it was not considered that it is a reply to notice letter of the client, and it was not his advice, nor he insisted to pay the bribe, and therefore he filed a review petition before the Bar Council. Bar Council considered all the documents and came to the conclusion that it was not intention on the part of advocate to insist his client to pay the bribe to the judge. or it was not his intention to scandalize the judge, but he considered interest of his client, and as he was aware of the fact, he replied the letter in that fashion. The Bar Council of India has accepted the plea, and it was stated that there is no misconduct. The matter went to the apex court, and here, friends, the apex court has considered it as a grave misconduct. Apex court has considered that advocate was the very senior most advocate, and therefore it was not expected from him even to reply his letter in such manner. The apex court has taken the view that the advocate may have knowledge about such rumors. Still, he could have avoided to give such guidance or reply the letter in such manner, and therefore it was treated as a scandalization of judicial officer, and it was treated as a misconduct. Not only this, being a senior most advocate, it was treated as a grave misconduct, and therefore punishment was imposed, that cancelling his sanad, and the Honorable Apex Court has punished that advocate, directing to cancel his sanad. It is a very known judgment, and we have to go through such a judgment where advocate was in dilemma. So how to protect his client also, and even how to avoid the misconduct. Still, his reply was on record, which was a written reply, and therefore Honorable Apex Court has taken a strict view that holding that it was scandalization, and accordingly was punished. I will request my junior colleagues kindly go through the case of Shambhuram Yadav versus BCI, reported in 2001, JR 2001 Supreme Court, page number 2509. In such manner, now we have to consider how to practice and not to indulge into the misconduct. Now, friends, while concluding, I will just bring facts to your knowledge that during this last 4 months, due to the COVID-19, the advocates are not practicing, courts are closed, there are no matters and therefore no income. Several advocates who are dependent only on the profession are hand to mouth. However, as it is held that advocacy is a noble profession in the world, the advocates are prevented to do any trade or business whenever he is an advocate on record. Therefore, unless he suspend his sanad, unless he get his sanad suspended or surrender the sanad, he cannot do any trade or business, even for his livelihood. This situation might have cropped up first time, but now it is a time to consider that whether in such a situation, which is extraordinary, where advocate is facing the problem of bread and butter, whether they can be allowed to enter into trade and business for a particular period, etc. However, law is strict on this point. We have taken such subject before the Bar Council. However, apex body says that even passing such a resolution to allow the advocates to enter into the trade or business will not be proper. And accordingly, even our Bar Council has rejected such a resolution. Friends, even recently, there is order passed by the Honorable Apex Court, and it was again construed, and it is held that in any case, the advocate cannot enter into any trade or business unless he's suspended, he get his sanad suspended or surrender his sanad. No in any circumstances, Apex Court says that no, it is not allowed because it is a legal profession, it is a noble profession, and therefore, friends, I tried my level best to point out both the parts. Here we have to balance during our practice and see that will not be held responsible for any misconduct, even because of our inadvertent act. Therefore, during existence of the sanad, we cannot enter in any profession, service, trade or business except the advocacy. I pray that such a situation like the COVID period, during COVID period, will not come again. Otherwise, situation is like this. I will conclude to say that it is very sorry state of affairs at present. The advocates are not getting briefs, courts are closed, they are hand to mouth. There is one Marathi magazine which says that आई जेव घालीना आणि बाप नोकरी करू देना, बाप भीक मागू देना. In such situation also, we have to maintain our prestige and dignity towards the profession. By this, I conclude today's session. I am thankful to the organizers and the participants who have participated in the program and hear me patiently. Thank you. Thank you.
Thank you, sir, for such an informative session. This will surely work as a guiding force to all our attendees. With your permission, sir, can we go with the question answer round?
Yes.
Sir, the first question is that whom to approach if we have grievances with a judge?
If there is any grievance of the judge in lower judiciary, like the Taluka Court, CTC. We have to approach to the district judge, even to the High Court judge, administrative wing. There is the Registrar General also. The courses are open. We can approach to the same judge also. But it is said that you should approach with dignity. And therefore it is expected, I think that it is expected that in such matter, you should approach the judge, not in the open court, but even you can make your grievance to him also. If not, then authority is the higher authority. That is the for trial court, district judge, even high court, and registry. There is administrative wing in the registry. And final administrative officer is the Registrar General at Bombay. We can approach to the authorities.
Thank you, sir. So the next question is that how to maintain the balance between moral ethics and professional ethics.
Therefore, without going to sections and the technical laws, my session was on practical examples and the judgments of the apex court. Because as I said during my lecture that misconduct is not defined. Therefore, whether any immoral thing can be treated as misconduct, it is nowhere explained. Whether every improper thing can be treated as misconduct, that is also not held anywhere. Therefore, what is moral and what is immoral relates to the rules govern the practice of the lawyers. And then considering the duties of lawyers, the facts to be considered, whether it is moral or immoral. If it violates the rules, it is violates the standard practice of the advocate or standards of the practice, then definitely it comes to a misconduct. And to avoid that, we have to avoid the immoral things. Just now I have referred one of the case that some advocate has accepted huge amount under the garb of payment of court fees. That was immoral, basically. And therefore, if immoral turns to the misconduct, we have to balance while practicing to avoid such things, not to accept such things, which amounts to misappropriation. Therefore, just a moral is to be tested along with the other rules and norms prescribed for the practice of advocate. Then we have to balance the practice. Therefore, last example I have given, that advocate was in the dilemma, what to do. She has advice in the interest of client. Still it was held that no, you have scandalized the judge. And therefore, we should be cautious during our practice to follow the rules and morals also. That only I can say.
Thank you, sir. With this, we end our question answer round also. All the attendees are hereby informed that Advocate Amarjit Girase sir has consented to give us, to guide us in our 11th webinar, which is scheduled this Saturday. The details would be released soon on the Facebook and Instagram page of Legal XP. Now, it is our duty to express our deep gratitude towards our today's guest, Advocate V.D. Salunke sir, for accepting our invitation so graciously and enlightening us. Thank you so much, sir, for sparing time from your busy schedule. We also thank all our attendees for their valuable presence. Team Legal XP prays that you all stay safe and healthy. Take care, everyone.
Thank you. Thank you all.